They say the law is blind, but experience tells me it is often simply distracted. A judge spends a lifetime watching people arrive at the bench, carrying lives that have been folded, spindled, and mutilated by bureaucracy. Most cases that cross my desk arrive wrapped in paperwork so thick, so dull, and so painfully routine that if you blink, you miss the human damage concealed underneath. A parking citation, a municipal code violation, a small administrative squabble. These are the things that keep the gears of the city grinding. Usually, these matters belong in a hallway, settled by two reasonable adults with a modicum of common sense. But then, a child walks in. That is when the disguise falls away, and the court is forced to reckon with the reality of what it is doing. The morning Emily Turner entered my courtroom, the atmosphere was already heavy. It was carrying that specific kind of quiet that signals something is wrong before anyone has the words to identify it. Emily was 14 years old. Just 14. She sat at the plaintiff's table with both hands pressed tightly in her lap, shoulders curled inward, head bowed just enough to avoid making eye contact with the gallery. It was the posture of a child who has spent weeks apologizing for a crime she was physically incapable of committing. Beside her sat her mother, Sarah Turner. Her face carried the unmistakable, carved-in-stone imprint of working exhaustion. Not the theatrical distress you see from people who enjoy the drama of a courtroom, but the bone-deep, quiet fatigue that settles permanently behind the eyes of women who live on schedules too full, paychecks too thin, and sleep too brief to absorb one more unnecessary blow from the world. Across the aisle sat Officer Daniel Price. If you were looking quickly, you might have mistaken his posture for confidence. Arms crossed, back broad and rigid against the chair, eyes focused on a distant point. But after 40 years of this, I have learned the difference between confidence and contempt. Confidence listens. Contempt simply waits for the other person to stop speaking so it can enforce its own will. Officer Price wore his contempt like a uniform. He looked at Sarah and Emily the way a tired clerk looks at a stack of forms at 5 o'clock on a Friday, something inconvenient, something that needed to be processed, stamped, and removed from his view as efficiently as possible. I looked at the file, then at the child, then at the officer. I asked the clerk to call the matter. Sarah Turner versus Officer Daniel Price. Petition regarding an improper citation, escalated administrative fees, and subsequent harassment. I did not enter that hearing angry. Judges are not supposed to be angry. We are supposed to be attentive, alert to the facts, and guarded against the impulse to take sides. But as I watched that 4-year-old girl, I felt the familiar, sharp crystallization of purpose that comes when I realize that common sense has been entirely abandoned by the people entrusted to maintain it. I asked Emily her name and her age. I needed the room grounded in plain, unvarnished truth before anyone could retreat into the comfortable, protective jargon of procedure. Emily Turner, 14 years old. Then, I asked the question that would shatter the officer's carefully constructed narrative. I asked her if she was driving the car. The answer was, of course, no. But the absurdity was only just beginning. I looked at the officer. He had claimed, in his official report, that the driver had refused to move the vehicle upon being instructed to do so. I repeated those words back to the room, letting them hang in the air until they sounded as ridiculous as they actually were. There was no driver. There was only a terrified child in a locked car, and an officer who had seemingly forgotten that a badge is supposed to be a tool for public safety, not a weapon of administrative convenience. Sarah Turner took the stand next. She didn't look for sympathy. She didn't perform for the cameras or try to weave a dramatic narrative. She laid out the facts with the clinical precision of someone who has spent her life managing crises that the rest of the world considers mundane. It was a Tuesday. She was working double shifts. She had stopped at the grocery store on her way home because the house was out of milk and her head was throbbing with a migraine. The parking lot was a war zone, crowded, raining, miserable. She told Emily, who was exhausted from a long day at school, to stay in the car, lock the doors, and wait. She was gone for 7 minutes. 7. That was all it took for the machinery of the municipal system to descend upon them. When Sarah returned, the groceries were in the trunk, but the atmosphere was shattered. Emily was crying. There was a bright, offensive slip of paper tucked beneath the wiper blade, a parking citation for being in a no-standing zone. And there, walking away with that self-assured, bureaucratic stride, was Officer Price. I asked Sarah what happened when she finally caught up to the situation. According to her, and corroborated by a frightened Emily, the girl had lowered the window just enough to ask what the paper was. And what did the officer tell her? He told the 4-year-old child that the vehicle was standing illegally and that the driver had refused to move it. The word driver hung in my courtroom like a foul odor. It was the keystone of the officer's report. It was the justification for the fines, the late fees, and the administrative nightmare that followed. Sarah explained that she had tried to do the right thing. She had called the municipal office, fully expecting that a human being with a pulse and a shred of logic would hear the story. My daughter is 14. The car was off. I was in the store for 7 minutes and immediately nullify the ticket. She expected an apology. She expected the system to work. Instead, the system did what it does best. It processed. The ticket remained. The late fees were added. Then, the administrative charges piled up. Because Sarah couldn't pay the total immediately without sacrificing her daughter's school supplies or their groceries, the debt grew, feeding on its own momentum. One officer's failure of judgment, one moment of laziness in a parking lot, had become a month-long, agonizing drain on a household that was already operating at its breaking point. I looked at Sarah, then at Emily, and I asked the question that truly matters when you strip away the legal terminology. I asked her, not what did the paper cost, but what did it actually cost your family? Sarah hesitated. She took a breath, and for the first time, her composure fractured. She told me about the overdraft fee that hit when an unexpected bill cleared. She told me about the groceries she had to cut, the bills she had to shuffle in order of urgency, and the silent, heavy tension that settled over their dinner table. Emily had heard every strained conversation about that ticket. The child had stopped drawing. She had stopped sleeping. She had started apologizing to her mother for ruining everything. This is what a single act of institutional laziness does when it lands on a family balancing on a thin margin. It doesn't just cost money. It costs peace. It costs childhood. I turned my chair, and with it, the entire focus of the courtroom, toward Officer Daniel Price. He didn't flinch. He sat there with that practiced, sterile indifference that men of his particular temperament often mistake for professionalism. I asked him to explain, not to recite, but to explain his reasoning when he decided that a parked, unoccupied vehicle containing a 4-year-old child warranted the full weight of a municipal citation. He leaned forward, adjusting his duty belt, and gave me the answer. I expected the answer that has insulated more foolishness in this country than nearly any other legal concept. I followed protocol, Your Honor, he said. The tone was clipped, meant to signal that my question was beneath his pay grade. The vehicle was in a no-standing zone. It had not moved for the duration of my observation. I am required to issue a citation in such instances. I let the word protocol hang there for a second. It is a word that acts as a shield for those who have surrendered their common sense at the door of their precinct. It is the language of someone who has stopped viewing the world through the lens of human experience and started viewing it through the lens of a manual. Officer Price, I said, my voice dropping into that lower register that usually tells the experienced litigators in this room to start paying attention. Do you understand that a 4-year-old child is not a licensed operator? She cannot move the vehicle. She cannot legally drive. She was sitting in a locked car, exactly where her mother told her to sit, waiting for the return of an adult. Does your protocol make no distinction between a driver who is actively parking in a restricted zone and a child who has been abandoned in a vehicle by necessity? He didn't miss a beat. The code does not reference age, Your Honor. It references the vehicle. The vehicle was illegally stationed. The citation was issued to the vehicle. That was the moment I realized this wasn't just a simple case of incompetence. It was something far more dangerous. It was an intellectual laziness so profound that it bordered on cruelty. He had reduced a scared, waiting teenager to a set of digits on a computer screen, a unit of traffic enforcement. He hadn't seen a child. He hadn't seen a frightened girl. He had seen an opportunity to clear a zone and hit a quota without having to exert the effort of a single human conversation. I opened the file my staff had compiled. By this point, my researchers had done the work that a working mother, struggling to put food on the table, could never have managed between double shifts. They had pulled the citation patterns, the complaint logs, and the body camera footage from that specific curb zone over the last 6 months. It wasn't an isolated incident. It was a harvest. I looked at him again. You say the code doesn't reference age. Does the code require you to be blind to the humanity of the situation? Does the protocol prevent you from knocking on the window and asking, Is everything all right here? Or, where is your parent? He opened his mouth to give me another lecture on policy, but I cut him off. The courtroom was silent, the kind of silence that happens right before a storm. I wasn't just annoyed. I was watching a man justify the systematic bullying of the vulnerable, and I was not going to let him hide behind his badge for 1 second longer. I opened the file my staff had prepared. By the time this case arrived before me, it was no longer simply a matter of Sarah's account against an officer's. My researchers had done the work that an overburdened working mother simply cannot be expected to investigate between jobs, dinner, and the constant gnawing worry of keeping the lights on. They had spent weeks digging through citation patterns, complaint logs, and body camera records. They had cross-referenced municipal codes against the specific geography of that high-yield curb zone. What they found was not an isolated error, it was a pattern. I started reading from the file, my voice low and deliberate, ensuring every syllable landed. Over the preceding 6 months, Officer Price had issued a disproportionate number of citations in that exact location, under circumstances that raised not just concerns, but red flags. There was the case of the disabled woman who had been unloading heavy bags of groceries. Her state-issued placard clearly displayed on the dash. Officer Price had cited her anyway. When she later contested it, he claimed he hadn't seen the placard, a claim that defied the laws of physics, given the photographic evidence provided by the woman's dash cam. There was the delivery driver who had been cited while he was literally collapsing on the sidewalk from heat exhaustion, unable to return to his vehicle immediately. Instead of offering a bottle of water or checking for a pulse, Officer Price had offered a fine. And then there was the pregnant woman who had been forced to pull over because she was experiencing severe dizziness and needed a moment to breathe before she could safely drive again. She was cited for abandoning the vehicle. In each of these instances, the documentation was pristine. In each instance, the officer had an explanation ready: procedure, volume, efficiency. It is the vocabulary of a person who has stopped seeing human beings and has begun seeing only quota opportunities. It is the language of someone who has lost the moral capacity to distinguish between an inconvenience and a crisis. I looked up from the file and locked eyes with Officer Price. The broad-shouldered, rigid posture he had maintained at the start of the hearing was beginning to fail him. The air was leaking out of the room, and he knew it. I told him, "Officer, you are not a machine. You are a public servant. And there is a world of difference between enforcing the law and using the law to make your shift feel purposeful by preying on the distracted, the isolated, and the vulnerable." He tried to interrupt, to offer another defense, but I wasn't finished. I wanted him to understand that while he thought he was hiding behind the anonymity of his badge, he was actually exposing the hollowness of his character. I laid the evidence out not as an attack, but as a mirror. I wanted him to see, as clearly as the rest of the courtroom saw, exactly what his protocol looked like when it was stripped of its procedural paint. "You didn't see a 4-year-old child, did you?" I asked, my voice echoing in the sudden, suffocating silence of the courtroom. "You saw a transaction. You saw a piece of paper you could sign that would pad your stats for the day, and you didn't care whose life you turned upside down in the process." He attempted to retreat into the language of the neutral observer, the kind of sterile, hollow syntax that public servants use when they are trying to convince themselves that their cruelty is actually legally just. He said the zone was posted. He said the rule applied equally to everyone, regardless of age. He kept saying, "I am a neutral enforcer, Your Honor." I didn't let him finish the sentence. "Neutral?" I repeated, and I made sure the words sounded like a question and a condemnation simultaneously. "Officer, there is nothing neutral about choosing to target a 4-year-old child because she is the easiest mark on the block. Neutrality implies that you are weighing the facts of a situation. You didn't weigh anything. You saw a target. You saw a child who was too intimidated by the sight of a badge to argue back." I motioned to the clerk, "Bring up the municipal code, page 42, section 3. The alternative enforcement guidelines." The room went completely still. Even the bailiff, a man who had seen everything this city had to offer, leaned in to look at the screen. I pointed to the text projected on the wall. It was clear, plain English, the kind of language that bureaucracy usually tries to bury under layers of fine print. It detailed specific alternatives for officers encountering unattended minors in restricted zones. Welfare check, a temporary warning notation. Escalation to a supervisor if the circumstances were unclear. There were, at minimum, 4 possible responses he could have chosen before reaching for his citation book. He hadn't chosen a single one. He hadn't performed a welfare check. He hadn't issued a warning. He hadn't called for backup. He had selected the one option that required him to do the least amount of thinking and caused the maximum amount of damage to a family that was already hurting. In other words, I said, my voice echoing against the wood-paneled walls, you had a map, you had a compass, and you had a moral imperative to help, and you chose to throw the map away because it was easier to act like an automaton than a human being. Officer Price's shoulders stiffened. The jaw I had been watching for the last 10 minutes suddenly set itself into a hard, defensive line. He wasn't looking at me anymore. He was looking at his hands, which were resting on his knees. He began to look less like a pillar of authority and more like a man who had suddenly realized the floor beneath his feet was made of glass. The courtroom had by this point stopped being a collection of strangers waiting for their own turn before the bench. They were no longer checking their watches or fidgeting with their papers. They were a single, unified body listening through one collective nervous system. The delivery driver in the second row, a man who had likely been on the receiving end of similar arbitrary enforcement, gave a small, almost imperceptible nod of agreement. An elderly woman in a red scarf, who I suspect hadn't understood half of the legal nuances, whispered loud enough for the first 3 rows to hear, "That poor baby." He didn't have an answer. By the time I turned back to the page in the manual that outlined his duties, the silence in that courtroom was so thick you could cut it with a knife. He realized finally that his posture wasn't doing the work he expected it to do. His badge wasn't a shield anymore. It was the very thing that was illuminating his cowardice. The silence in the courtroom was absolute. It was the kind of heavy, pressurized stillness that only occurs when the veneer of officialdom is stripped away, leaving nothing but raw human truth. Officer Price sat motionless, staring at his hands as if he were trying to find an escape route written on his own palms. He had come here expecting a simple rubber stamping of his authority, a quick administrative procedure to validate his conduct. Instead, he was being dismantled, piece by piece, under the glare of public accountability. I let him sit in that silence for a moment longer. It was necessary. Some people only understand the gravity of their mistakes when they are forced to inhabit the vacuum left by their own ego. The citation, I began, my voice steady, slicing through the tension, is void. Every fee attached to it, every late charge, every administrative penalty that has been piling up like trash in that poor woman's mailbox, it is all void. I am directing the clerk to clear the record entirely. As far as the law is concerned, this never happened, because it shouldn't have. I saw Sarah Turner's hands begin to tremble. She didn't sob, but the tears finally came silent, slow tracks down a face that had carried too much weight for far too long. She had spent weeks terrified, navigating a labyrinth of red tape that was designed to make her give up, to make her pay just to stop the noise. And now, the noise was gone. "But that," I said, my gaze shifting back to the officer, who was now forced to look up and meet my eyes, "is not where this ends. You seem to believe that your badge grants you the right to treat the public like a collection of data points rather than living, breathing people. You are wrong." I motioned to the clerk, who already had the paperwork waiting. "I am ordering the complete file of this case, including the patterns of enforcement my researchers have documented over the last 6 months, to be referred immediately to Internal Affairs and your department's command a review. They will examine your history of ticketing the vulnerable. They will evaluate whether you are capable of exercising the discretion that your job requires. If they find what I have found, then this will be the least of your concerns." Officer Price finally shifted, his face pale, his jaw locked. The bravado, the crossed arms, the don't question me attitude had evaporated. He looked, quite suddenly, like a very small man in a very large uniform. He realized, perhaps for the first time, that the uniform doesn't confer status. It confers responsibility, and he had failed it. "Authority without common sense is dangerous," I continued, speaking not just to him, but to everyone in the room. "Authority without compassion is worse, and authority directed against a child who was sitting in a car, locked, safe, exactly as her mother told her to be, because the adult holding that authority cannot be bothered to think, that, Officer Price, is contemptible." He didn't speak. He couldn't. The courtroom was no longer a collection of strangers. It was a jury of peers, and they had seen the truth of his character. He looked reduced. That is the one useful capacity a courtroom retains. It can strip away the pretense of a title, the protective armor of a uniform, and leave a person standing only within the reality of what they actually did. I issued the ruling with the finality of a gavel strike that echoed in the marrow of the room. The citation was void. Every penny of the late fees, the administrative costs, the processing charges, all of it was erased. I directed the clerk to clear the record entirely, as if the entire humiliating ordeal had never touched the Turner family. But that was merely the technical side of justice. I wasn't done. Furthermore, I said, leaning forward until the microphone picked up the quiet friction of the wood, I am ordering this entire file, including the complaint history, and my findings regarding the enforcement pattern I have just reviewed, to be referred to Internal Affairs and Departmental Command for a comprehensive review of Officer Price's conduct. They will evaluate whether the patterns displayed here represent a standard of service that this city finds acceptable. I suspect they will find, as I have, that they do not. The room collectively exhaled. The tension that had held us all captive for the last 20 minutes seemed to dissipate, replaced by a strange, fragile sense of equilibrium. I looked directly at the officer. A badge, sir, is not a license to select easy targets. Public order is not preserved by treating the vulnerable as if they are merely convenient paperwork. You have mistaken your authority for a mandate to be thoughtless, and in this courtroom, that is a failure that will not stand. He looked, quite literally, diminished. It is a peculiar thing to watch. He hadn't physically moved, he hadn't shrunk, and yet the visual authority he had carried when he walked in that swagger of unquestioned power was gone. He stood there, stripped of the pretense, left only with the cold, hard reality of his own actions. That is the one useful capacity a courtroom retains, and it is the one thing no officer can ever fully prepare for, the ability to strip away the uniform and leave the person standing only inside the truth of what they actually did. I didn't know what the internal affairs process would produce beyond what the formal record allowed me to observe. I knew the review would proceed. I knew the file would not be quietly set aside. And I knew that, at the very least, Sarah and Emily Turner had recovered their lives from a piece of paper that never should have been written. But what remained with me most was not the officer's expression of defeat. It was Emily's. Sarah looked at me, not with the performative gratitude of a litigant hoping for a smaller fine, but with the raw, shattered relief of someone who had been holding her breath for a month and was finally allowed to exhale. People speak about tickets as though they are just paper. They are never just paper. To a household balancing on a razor-thin margin, a ticket is weather. It changes the atmosphere of the kitchen. It changes the tone of the mother's voice when she opens the mail. It changes the quality of a child's sleep. And that day, I had managed to clear the clouds. "This court is adjourned," I said, but for a few seconds, nobody moved. They were all still watching the girl, who had finally let her shoulders drop. For the first time in weeks, she didn't look like she was apologizing for existing. She looked like a child again, and that, more than any ruling, was the only victory that mattered. I kept returning to the language in the file. Driver refused to move vehicle. A line of text, cold, neat, and administrative. And concealed inside it was a complete moral failure. A child alone in a parked car. An adult with a badge. A moment that called for one more question, 1 second of empathy, and a choice toward decency. It was missed, simply because it was easier to be rigid than to be right. That is why I tell people that court is rarely only about the paperwork. It is about the sentence beneath the sentence, the fact hidden inside the form, the human truth embedded within the administrative claim. If you read only the citation, this was a parking matter. If you listen to the people, if you look at the terrified girl and the exhausted mother, it was a story about power selecting the smallest available target. No court that functions honestly should ever overlook that. People have complained for years that judges interfere too much, moralize too much, push into what should remain simple. Let them complain. Simplicity is frequently only the name given by comfortable people to someone else's suffering when they prefer not to examine how it began. This case required examination. It required stating plainly that a child is not collateral for a parking officer's carelessness. It required telling a working mother that the law had no legitimate claim to make her poor because someone in a uniform stopped thinking. And it required reminding one very certain officer that public service is not measured in the volume of citations tucked under windshield wipers. It is measured in judgment, in decency, and in knowing when the law exists to protect and when you are simply using it to make your shift feel purposeful. A month later, Sarah sent a brief note, nothing elaborate, a thank you and one update. Emily had started drawing again. That sentence remained on my desk longer than it needed to. Started drawing again. There it was. The entire case reduced to what had always been at the center of it. A child who had briefly stopped being a child because adults in authority made her feel responsible for damage she had not caused, was returning to herself. No statistical report is capable of adequately measuring that outcome. I do not share these stories because I take satisfaction in condemning public servants. Most of them work genuinely hard. Most are underpaid, overburdened, and attempting to maintain order within systems designed by people who rarely have to stand in the weather themselves. But that is precisely the reason to speak clearly when one of them forgets what the badge represents. Public service depends on trust, trust depends on judgment, and judgment depends on the refusal to ever mistake a vulnerable person for a convenient target. If you ask me what made this case significant, it was not complexity, it was clarity. One child, one mother, one officer, one wrongful citation, one opportunity for the court to either participate in the damage or stop it. I stopped it. And that is why I still believe in this bench when it is being used properly. Not because robes carry weight, not because gavels make noise, but because every so often a frightened person arrives in this room carrying a lie some institution has attached to them. And the law, when it is functioning as it should, gets to answer back, no, that child is not the problem. No, that family will not carry this one day longer. No, a badge does not transform indifference into wisdom. That is justice without ceremony. And on that morning, justice without ceremony was exactly what Emily Turner had earned, simply by doing what her mother told her and waiting in the car.